Hello everyone, I'm Khushbu Nathalia and thank you for coming back to my channel Conceptual Legal. Let's suppose that we have four people A, B, C and D and they are going in a ship and the ship is hit by a storm. So four of them, obviously along with other people in the ship, these four people, they try and escape and they find a lifeboat nearby and they have nothing to eat at all with them. Now, among these four people, the fourth person, he is the youngest, he is an orphan, he do not have a family to look after and they just try and escape in that boat. During the course of their travel, they find that whatever little they had to eat, even that is finished. And it's almost a week that they are not getting anything to eat and they probably are gonna die of starvation. In the meanwhile, this fourth child, or who's just a 7-year-old, not a major yet, he drinks the sea water and he gets ill. So the rest of them, they think that we need to do something, otherwise none of us is gonna survive as we are not able to see any help coming our way. So they decide that let's have a draw of lot and whosoever names comes out, we are gonna kill that person and the other three can feed themselves on his body. So one of them refused because he thought, what if my name comes over? So the day passed off and the starvation was increasing, and as they have not had food or water for almost a week or 9 days, so they decided that why not to kill the fourth one, because he is an orphan, he do not have a family to look after and he is already ill. So if we do not get any help, he is ultimately gonna die. So why not just kill that person? So the three of them went to him and said a prayer and said, your time has come to go, and they killed him. Well, if you have read IPC, then you must by now have figured out that I am talking about the English case which by the name of Queen versus Deblay and Stephen. So now, why am I telling you the facts of the case? Because I want to know, what do you think? Was it justified to kill that person so that the three of you or the three of the other people can survive on his body till the time they do not get any help? Or was it wrong on their part? Well, the answer varies from person to person. Some of you may say, ki, okay, fine, at least if not all, at least three could survive, so it was okay, and anyhow he would die. The others would say that no, it is not justified to kill anybody. But if I just add one more thing, that what if the fourth person gives his consent to die, then in that case, what will you think? Then might be you may say a yes for it, ki alright, since he has consented himself, so it might be just. Well, the topic we are going to discuss today is justice. Justice, which means nyay, and which varies from people to people. We do not have a set definition when it comes to justice. What might be just for one may not be just for another. For example, in this case, it was just for the three of them so that they could survive. But it was unjust for that fourth person who had to die. When we talk about justice, we talk about the justice delivery system. How does that impart justice on people? That means the judiciary particularly. And if I talk about judiciary, then I need to understand what is the manner, what is the procedure that the judiciary need to follow so that it do not do any injustice to anybody. So let me start with the principles of natural justice which need to be followed by all the judicial and quasi-judicial bodies while imparting their decisions, while delivering their decisions and imparting justice to the general public. The first maxim of principle of natural justice, which means no one can be a judge in his own case. Why? Because of the obvious reasons of biasness. If one is gonna judge himself, then there will be a reason of biasness by which he will not be able to deliver the justice which need to be delivered in that particular case. The next talks about the opportunity of fair hearing to the other side, which is Audi Altram Partum. Whenever we talk about a particular case, there are two parties. One is a plaintiff, one is a defendant. And we need to give a fair opportunity of hearing to both the sides so that both of them can present their case in the best possible manner, and according to the facts and circumstances, the issues, the evidences, according to all these things, then a decision is taken by the judge. So let's presume that if we do not give the opportunity of rebuttal to the other side, in that case that person is deprived of his right of a fair trial, which is infringement of his right and which is causing injustice to that person. So that should not be done. When we talk about a fair trial, there should be a fair notice, evidence, cross-examination opportunities, opportunity for them to present their case, to argue their case, to defend their case. Everything falls in that category, and both the parties have the right to present their case, to be heard by the court before a judgment is delivered. This particular maxim was even highlighted in the infamous Menka Gandhi versus Union of India, and they say that the rule of Audi Altram Parte is intended to inject justice into the law, and it should not be applied in a manner which defeats the ends of justice. So these are the two principles of natural justice. If you see the Constitution of India, the very preamble talk about justice in the form of social, economical and political. And we see various provisions under the Constitution of India where we have relevant provision dealing with social, political and economical justice. For instance, if I talk about the fundamental rights, you have these various kinds of right to equality, right to freedom, right against exploitation, cultural and educational right to constitutional remedies. So the main aim of these rights is to impart justice to the people. For example, if I talk about constitutional remedies, so if there is any injustice done to you, if your right is infringed, you can go to the court, you can go and file a writ, and you can read and you can gain your rights, right? So that's one. Similarly, when I talk about right to equality, the focus, the main aim is to have a social welfare in the state. Although if I talk about these 14 provisions from 14 to 18, we have provisions of reservations for socially and educationally backward people. So it helps in their upliftment. It is to have an economic welfare of those people. So different provisions have different motto behind them to impart justice, whether in the form of social or political or economical. Similarly, when you see the Directive Principles of State Policy, specifically your Article 38 talks about justice in the form of social, economical and political again. And further, it laid down various directive principles which need to be followed for the proper governance and welfare of the people by the state. Although they are not enforceable, but they are very important for the welfare and the governance of the people. Let me just take for example, if I talk about free legal aid, it helps in imparting justice so that the people who are economically not that good or who do not have that much of money to spend, even they are not denied justice, and even they can have a proper trial by the help of legal aid being given to them. Similarly, equal pay for equal work, that also helps in the economic development of the country. Then you have right to education and number of other rights. So different DPSPs are there which are either for getting justice in the form of social or economic or political. Apart from this, you have various laws which helps in providing justice to people. The two major categories are civil and criminal. When I talk about civil laws basically are those which comes into picture when there is an infringement of a legal right of individuals, and which is not affecting the society at large. For example, if I make a contract to deliver goods with B, and the B has to pay me certain amount for that delivery, and he do not pay me that amount, in that case what will happen? He will be liable to pay me compensation. I can demand compensation from him. It is a civil wrong. Alright. Similarly, on the other hand, if A rapes B, in that case it affects the whole society, and particularly the women's or the girls or the female section of the society, because it causes a lot of danger, or it creates an unsafe environment for them. So that comes under criminal laws. The provision of rape which are there under IPC, they are governed under criminal law, and it is a wrong against the whole society, and it is punishable in the form of an imprisonment or fine or both. So this is how in India and the other country, we see that the justice is delivered. We have the constitution, which not only have the fundamental right or the DPSP, but other provisions also. For example, if I talk about political right, so we have the right from the employment to the qualifications and to the method of removal of various MLAs, president, vice presidents, or the cabinet minister, everybody you can think of who forms the political society in the country. We have all the provisions listed in the Constitution of India, and it is according to those provisions that they are either appointed or removed, or their tenure is decided, or their office or profit, your salary, everything is governed accordingly. Similarly, you have distribution of powers between the union and the executive, or the three organs of the government, which again help in the functioning of the government. So even the motto behind that is also to have a welfare state and to impart justice on people. Apart from that, you have various other laws in the form of either civil or criminal, which helps in the proper administration and proper working of the state. So this is how the justice is delivered when we talk about India. Now, different jurists gave different theories when it comes to justice. The first in the list which we're going to talk about is RAWL'S theory. Well, he says that in the original position, we have different people. They differ on the basis of their religion, race, caste, age, sex, color, and education level, the monetary level, economic level, everything, something or the other, and there is a difference. They are not at the equal footing. So when in the original position, if I talk about policy making or law making, then जो जिस कैटेगरी में है वो उसके अकॉर्डिंगली ही लॉ बनाएगा. फॉर एग्जाम्पल, अगर आप मुझसे पूछेंगे तो आई विल मेक लॉ which I feel that should benefit me. For example, being a girl, I make laws on something related to feminism. And if I ask somebody from ST/SC category, so they will make laws for their upliftment. For example, their reservations in the educational institutes or working, or on the other hand, if I talk about the other people, then or the rich peoples, then they might talk about tax laws. So it varies from people to people. All right. So he says that it becomes very difficult to understand what is gonna be a law which is just and which can do justice. So he says, let us have a wheel of ignorance. That means let us ignore the original position and create a wheel of ignorance wherein everybody is at the equal footing. ना ही कोई गरीब, ना ही कोई अमीर, ना ही कोई बीमार, ना ही कोई स्वस्थ, ना ही कोई लड़का, ना ही कोई लड़की, सब बराबर है. Everyone is at an equal footing. So now at this footing, when they will make laws, it is gonna be just. So we need to make laws in this wheel of ignorance when everybody is equal and no one is thinking about themselves because everyone is at the same footing. So at this point of time when the law is made, it will be termed as a just law. But the fact of the matter remains that this is a wheel of ignorance and not an original position. So when this wheel of ignorance is removed, we come back to the original position where everyone is at a different footing. So what will happen then? If, for example, when the wheel of ignorance is removed and I become the part of a minority community, then what will happen? Will I not want that my liberties, my rights should be protected? Or will I be like, let's follow the utilitarian and let's talk about the benefits or happiness of maximum people and ignore the minorities? No, I don't think that is going to happen. Because everybody, whether they fall in whatever category, everybody wants their liberty, their rights to be intact. So he talks about the liberty principle. That's the first principle given by him. And he says, no matter wherever, whichever position you gain when you come to your original position of the society, everybody wants their rights to be intact. And they need to have that liberty and freedom to do what they want and to have all the rights of which they are entitled. So that's the first principle. And then he comes to the difference principle. Right? When I talk about difference, let me give you an example. There is this person who is a rickshaw puller. And let's say that he earns around 5,000 rupees in a month. And then there is a doctor and he earns around 1 lakh or 2 lakh a month. There is a difference in the earning, right? So can I say that difference is not justified? Because this doctor, he has a particular he has a particular education because of which he is at this particular platform that he is able to earn this much. And he, a rickshaw driver who probably of whatever reasons was not able to be that educated and he is pulling a rickshaw for the whole day and that's how he earns his bread and butter. The difference in their earning, can that be justified? So he says only those inequalities that work for the benefit of the least well-off are just. Which means he says he is educated, alright. He is earning this much, very good. But these people who are not able to earn this much, even their rights need to be intact. So if we can tax these people who are well-to-do off and distribute that taxed income for the benefit of these, then that is justice. That is the reason we have a tax system in India also. And we have different slabs for tax. It is not that what the amount of tax which I pay is the same of what Ambani pays. Why? Because the income is different. So we pay according to the income we have. And we then distribute it, we in the sense the government then distribute it for the betterment of the least well-off people in the society. So that is what is RAWL'S theory of justice, which talks about two principles, liberty principle and difference principle. The last in the list is Robert Nozick. According to him, he says that when we talk about difference, the only thing which matters is that there should be justice in initial holding and the justice in transferring those things, which means that whatever resource you use to make any legitimate money yours, are they just? आपने कुछ बुरे तरीके से या किसी को चीट करके तो कुछ नहीं लिया है, और दूसरा आप उसको ट्रांसफर कैसे किया गया है, whether it is done by a free exchange or your free will. In that case, if both the answers are yes, then and only then this process of distribution can be termed as just. According to Robert Nozick, he is a libertarian. He feels that that a person should not be used merely as a means to welfare of another, because doing so violate their fundamental right of self-ownership, which means my work, my labor, my efforts and my money. I cannot be compelled to give my labor fruits to anybody else. I can do that only if I wish to do it, and nobody can compel me to do it. If anybody compels me, then they are infringing my right of self-ownership. Self-ownership means that whatever I have, I own it, and there is a power of ownership on it. So I cannot be compelled to give something which I own to somebody without my free will or consent. If I am compelled, then it amounts to infringement of my fundamental right of self-ownership. So the difference between these two theories is that Rawls' theory talk about the two principles, and he says that if the inequalities which is there, if we work for the upliftment of the least well off, then it is just. But Robert says that when you talk about distribution, you need to take into consideration two things: justice in initial holding and justice in transfer. If the answer to both of them is right, only then the distribution is just. Otherwise, it amounts to violation of the fundamental right of self-ownership. So in this way, he was somehow against the taxation process. And he felt that only if I feel like contributing amount of my money, then only it should be done. The government cannot tell me that since I am earning this much, I need to pay this much. Why? Because what I earn it according to my labor and my own hard work. And that is the reason I have an ownership on it, and I cannot be compelled to pay anything out of that unless and until I do it willingly. So that's all about justice. I hope you understood. If you have any queries, please put them below in the comment section, and I'll see you in the next video. Bye-bye.